Okay, Megan, you can go ahead and start when you're ready.
Okay. The Behavior Analysis Regulatory Board meeting is convening at 9:10 a.m. on July 16th, 2021 at the Health Licensing Office in Salem, Oregon by telephone conference call. I will now call roll. Megan John, here. Brenna Lagarde.
She's on the camera, but it doesn't look like she can hear us or we can hear her. She might be trying to call in. Yeah, I think she's trying to call in. Yeah, no, Brenda's trying to call in, I do believe, right now.
Yeah, that's her.
Okay. Sorry, I think my internet's a little spotty.
Oh, sorry, Megan. So, Brendan, can you hear us now?
Yeah.
Okay.
Can you hear me?
Yep, we can hear you.
Yes, we can.
Brad Hitchcock.
I'm here.
Corey Stump. Here. Okay. Samantha Parham. Here.
Oh, Megan, are you still there?
My internet is really bad. I'm at Hood River.
Oh, gotcha. If you want, Megan, you can,
I can't hear anybody. I don't know if you can hear me.
I can hear you. Can you hear me?
I think you were asking if you want to do it, and I said, and I think yes.
Do you want to call in? You can call in to the phone number. You'll
okay.
Hear a little bit better versus using the internet.
I'll try that.
Okay.
I'll try that.
Megan Johns, she's the chair here. She didn't get through, roll, so.
Okay, she's on.
All right, Megan, you back on now?
Yes. Can you hear me?
I can hear you just fine, yes. Can you hear me fine?
Perfect. I think so. So far, so good.
Okay, good. Okay, so you're still on the roll call. I think we heard you say Samantha and Brad, I think. And so I do believe that's where you're at.
Okay. So Maria McMahon. Marie, here. Jennifer White. Here. Great. Members, when you wish to speak, please state your last name for the record. For the record, public members calling into the public phone line are asked to email April Fleming at april.fleming@dhsoha.state.org.us and provide your first and last name. Public and interested parties feedback may be heard during the public and interested parties feedback period if indicated on the agenda. Everyone is asked to use the appropriate language, manners, and protocols when conducting board business. This meeting is called to order.
Good job, Megan. Okay, this is Sylvie. First item on the agenda is approval of the agenda.
This is McMahon. I move to approve the agenda.
This is Brad, I'll second.
A motion has been made. I'll call the roll. Megan Johns? Yes. Brenda Lagarde? Yes. Did you hear me?
Yes, I heard you.
Okay.
Uh-oh, did we lose Megan?
She's muted. Oh, no, so am I.
Megan, are you still on there?
She's muted.
Oh, and then Megan, if you're talking, you might be muted. Well, okay. Well, let's just keep going. So, Corey,
Yeah.
Samantha,
Yes.
Brad,
Yes.
Marie,
Aye.
and Jennifer.
Yes.
Okay. All right, so this is Sylvie moving on. Hopefully Megan can get back on. So now we're on the agenda on item number 2. So we have the approval of the chair and vice chair and meeting dates, both for next year. Since this is your last normal meeting of the year, we might have another one later in the fall to address some regulatory stuff. But we have picked out, and you should have this in your materials, and hopefully you've had a chance to review it, but January 21st and July 15th at 9 a.m. If nobody has any concerns, then, if you do have concerns, we're welcome to talk about it. We have a calendar, we can change things around if we need to, but we need you to approve those dates.
This is McMahon. I move to approve the meeting dates.
This is Brenna. I second.
Okay. I will call roll. Indicate with yes or no, or yay or nay, either way, however you prefer. Megan, are you back on? Apparently Ben doesn't have good service over there. Brenna.
Yes.
Corey.
Yes.
Samantha.
Yes.
Brad.
Yes.
Marie.
Yes?
And Jennifer.
Yes.
Okay. Next item is the chair and vice chair. So currently Megan is serving as chair, Brenna is serving as vice chair. And you do not have to change it. You do have to vote every year for chair and vice chair. And I have the spreadsheet up. There is nobody who is terming out. The next term would be, looks like Megan's first term goes all the way through December 16th of 22. And then people don't term out until 23. So you're welcome to keep it how it is, or you can change it if either Megan or Brenna do not want to continue serving.
Megan, I'm here. My audio is so terrible.
So I do believe I heard Megan say that she's here, but her audio is very terrible. So I'll just continue, Megan, I'll just continue running the meeting for you. Or Brenna can do it too, but I think Brenna was having issues with her audio too. So it's up to you guys, however you want to do it.
You got it, Sylvie. Go for it.
It's also a little hard when everybody's doing this remote stuff too, and we're not all in the room.
This is McMahon. I move to approve the chair and vice chair.
As they currently are?
Yes, sorry, yes.
Yes, no, you're fine.
This is Brad, I'd second that.
Okay, a motion has been made and seconded to keep Megan is chair and Brenna is vice chair. I'll call roll. Megan?
Yes.
Brenna?
Yes.
Corey?
Yes.
Samantha?
Yes.
Brad?
Yes.
Marie?
Yes.
And Jennifer?
Yes.
Excellent. Okay. So let's move on. So next thing is director's report. Nothing major. So COVID-19, I know a lot of the restrictions have been lifted. However, the governor has not chosen to reopen state offices yet. So we still remain by appointment only. So our doors are locked. You can only come in if you have an appointment kind of thing. We are forecasted to reopen September 1. So come September 1, who is that?
That is somebody that's trying to call in, and I gave her the call in.
Anyway, so we're not scheduled to reopen to the public until September. That's pretty much the only director's report news that I have. We're going to continue doing this until then. We'll start to be able to have our board meetings back in the office after that, but we will also still have the access to Teams. So if you do not want to come into the office or you can't travel or whatever, then we'll still have the Teams on the screen, but we will be able to do in-person board meetings, which is a lot easier.
Uh-oh. What just happened?
Any questions on that?
I didn't see.
Screen went out.
No? Okay. So I'll just move on. So in your packet, you should have the licensing and statistics. I can kind of go through it real quick. But interrupt me if you have any questions while I'm talking. The first slide shows the licenses issued. So broken out by the different types, so behavior analyst, assistant behavior analyst, and the interventionist. Broken out by quarters, and our quarters are a little weird. State years go from July 1 through June 30th. So that's why it shows that the 2021 year is all done. Quarter 4 of 2021 is April, May, and June. So this is kind of how those statistics are done out. And then the bottom half of that chart is the renewals process. So you can see there in a 2-year cycle, we issued 135 licenses for behavior analysts, 15 for assistant behavior analysts, and 1,335 for interventionists. The next slide shows basically that same information, just a long-term trend. You can see back in 2017, which is when pretty much stuff started, well actually in 16, it's that quarter 1 of 17, which is actually July, August, and September of 16 is when it started, and this is kind of the quarterly average just moving forward. So you can kind of see the growth there. The next slide shows broken out by age and gender for the active behavior analysts. So as of July 13th, when this report was ran, there was 350. Next slide shows the same information, but for the assistant behavior analyst, which is, there was 13 or 19 of them at that date. Next slide shows the same information, but broken out for the interventionists. You can see there that they're very young group, but as of July 13th, there was 1,532 active licenses. And then the next slide just kind of shows that all that same information, but in more in a pie chart from all 3 licenses together in comparison. Next slide shows the financials, again broken out by our weird calendar years. So they go from July through June, and that's the financials. And then we inserted on the next slide, because you guys had asked about it, the last meeting we had sent out the 2019 and 2020 financial information broken out by the actual categories. And so we added to it the 2021 year. So that's the actual revenue and expenditures broken out into the different categories, because you guys had asked for that last time. And I didn't know if anybody has looked through that and has any questions, but I can kind of go through that if you want. If you look down towards the bottom where it says other services and supplies, it's a rather large dollar amount. So I saw that and instantly was like, what is that? So I went and dig in. They meaning accounting, codes the fingerprints, the cost that we have, the OSP charges us to process the fingerprints, that gets charged to other S&S, and that's why it's so large. So that's the fingerprint charge to run all the criminal background checks for every single applicant that comes in, and that is offset when an individual pays the application fee. So it is a very large dollar amount, but there's a lot of applications. So that's what that large amount is. Right below it is the direct and indirect allocated costs. Those are the costs associated with being with the Oregon Health Authority. So they assess us to be a part of them for shared services. Does anybody have any questions on the financial stuff? All right, you guys are an easy group. All right, next item on the agenda is the regulatory report, Bob.
Hi, good morning, everybody. Oh, okay, had to check, make sure I wasn't on mute. As you see in the regulatory report, it is a new report, a new format. So in 2017, all the cases are closed, and we did have a total of 3. That's the 17-19 biennium and the 19 biennium. We have, it shows 3 cases remaining open, but after receiving this report and doing a review, we actually only have 1 case open, and the investigator is actively working it, and we have 10 of them closed of the 13 we've had, and currently we have a total of 14 cases open and 13 closed, with a grand total of 27 for the entire biennium thus far. Any questions, concerns? Another thing I have for note is we are looking for subject matter experts to help us vet the investigations. So one of the things that we do is we send letters, we can send letters to the entire, everybody that has a license, to the entire community, and we also have in the past put it out on the website for folks to see and inquire. And what we typically look for with subject matter experts are folks that have been in the field at least 5 years, and their license is in good standing with us. And in this case, it would probably have to be good standing with your national organization as well. And what we do is we use subject matter experts through the investigations, since none of us are experts in this field here in the office, and we also use them at hearing if necessary. So we are actively searching.
So we'll send out, obviously we don't want an interventionist as a subject matter expert. I think the best what we would do is send the letters out to all the people who are actively licensed as an analyst. So there's only about 350 of them. So we can send out an email to all of them. And then there's a few associations that we could also, but obviously if we're sending it out to all the licensees, that we would want somebody who's, so we'll do that, and we'll get something posted on the website too, so. And then, just so everybody understands it, so then that subject matter expert will then work with the investigator and help the investigator in either reviewing reports, reviewing practice standards, kind of reviewing what is the norm out in the public, and also help the investigator create questions to try and clarify certain things, And then if the case goes all the way to a hearing, then that subject matter expert would also help Heather, and he or she would testify at the hearing as our subject matter expert on the specific case. And we contract with them, and so they do get paid. They don't get paid a ton, and so that's usually where you don't get a lot of applicants because they don't make a lot of money. So that's kind of where we're at. Does anybody have any questions on that or how any of that's going to work?
This is Megan. I have a question.
Yes.
How do they get vetted after they, you post the posting or whatever, and then they apply? What's the process for that?
This is Bob. So if somebody's interested, I ask them for a resume, which includes their work, their current title, education, and then I vet through our licensing database, and I'll look at the national standard. And a lot of times they don't understand that they may be involved and likely be involved in interviews, and sometimes that chases people away because the community is small, and they're worried about reputation or what have you, and that kind of scares them away. But they we just share with them what we do and what the expectations are. They'll have to write a report. And we, like I said, may be involved in interviews to help the investigator at that point ask follow-up questions and testify at hearings on our behalf. And sometimes that scares people away as well.
And to add to what Bob was saying too, so by law we have to have a contract with them. So once we get somebody who's willing to do it, then they actually have to go have a contract. Our Office of Contracts and Procurement will actually create a contract, and then they have to sign it. So they have to have insurance. They have to agree to everything. They have to sign it. It is a legal binding document, that kind of stuff. So there's a big old long process. The first process is trying to find people who are interested in it and willing to do, like Bob said, because you're going to be interviewing other people who are under investigation, and you may know them, or they may know who you are. And so that sometimes people don't want to get that involved. So first off, we got to try and find some people who are interested.
Yeah, and the time, this is Bob again, and the time commitment varies. It's not like a part-time job or anything like that. It's periodic. We do have cases. We don't have a lot, and once we get to a point where we need records reviewed, that may be all there is, or there may be a point where there likely will be a point where they're involved in an interview, and a lot of, I don't want to jinx myself by saying we don't go to court a lot, but periodically we find ourselves at the Administrative Hearings Office defending our stance, defending the board when we sanction a licensee. So, but yeah, I don't want to say it's not a huge commitment, but it is a commitment, and there are some things, but it's not enough to sustain and make a living off of it. So, any other questions?
Thank you.
Moving on. All right, that's all I've got.
All right, let's move on. Next thing is policy, and we do have, we're going to get in, let's do the rules first. So, and Ann's in the office with Bob if you guys have questions or need to talk to her, but she submitted in your packet the rule that you guys have been working on. So it's about the restraints, and I don't know if you guys want to talk about this at all, but she also then included, there was only one written comment that came from Araba, and it's not really a comment on rules, and so, but Ann put it in here so that you guys can read it, but it wasn't really a comment on the rules. It was just a comment about having a rules advisory committee, which you didn't need because you guys did it as a whole. And it wasn't all of your rules that were being reviewed, it was just that number 3. So, and that was the only comment that we got. So now we're in the process, as long as you guys are good with the verbiage number 3, to adopt this rule permanent. Does anybody want to talk about the restraint rule?
This is McMahon. I'm wondering, I don't know if this is nitpicking the verbiage or not, but when it says a policy in place for the use of restraints, should that be regarding the use of restraints instead of for the use of restraints? I don't want someone to be like, oh, we're having to talk about how we are going to do this, but leaving it open to say, like, your policy can be, we don't do it, and that's fine, but you have to have a policy in place. So I'm not sure if that's too nitpicky of wording or just to leave it, but that was the only comment that I had, was wondering about that word of for the use of restraints. I know it doesn't mean pro, I just discuss.
That sounds great to me. So you're recommending it say licensed behavior analysts and licensed assistant behavior analysts must have a policy in place regarding the use of restraints?
Yes.
Okay, we can do that.
This is kind of, I agree, I like that. I didn't even think about it until you said it, and I was like, oh, and it's like, yeah, go ahead, we're for it. No thanks.
That's fine.
Does anybody else have any comments on it?
This is Brad. Does anyone think that we need to, just like we see with Senate bills, have a definition of restraint where, what bill am I looking at? Senate Bill 710, that restraint means the physical restriction of a child in care's actions or movements by holding the child in care or using pressure or other means. I mean, or do we want to point to some definition that exists elsewhere?
So this is kind of a good point. Sorry, what?
No, go ahead.
I would say that's a good point, but I think what the intent was is that is up to each individual location, that this rule was intended to be broad. If you are going to use restraints, not you as an individual, your company has to have some sort of policy in place to address it, and you must abide by that policy. I think that was the intent, but
Yes, it was.
Anne's answering in the affirmative that yes, that is the intent.
This is McMahon. I think Brad brings up a good point I hadn't thought of, which though is that if someone doesn't consider what they're doing to be restraint, but we would, right? Like, so, and it's just, refusing to let someone leave a room, or to keep blocking them, but you're not physically touching them. I think it has to be, my concern was that, technically, I don't know. I just wonder about that. It feels like maybe there should be some type of guideline directing to what we are talking about when we say that you have to have a policy regarding it, because someone might not have a policy regarding the things that we consider to be restraints.
This is part of, we talked briefly about the ABAI's policy on it, and I feel like we talked through using their definition, but I can't remember where we left off. But theirs is very thorough. So I don't know what happened there, but there is a good one already available if we decide to go that way.
And this is Brad. I would also just propose the thought of including involuntary seclusion, which also under this particular Senate bill is defined as meaning the confinement of a child in care alone in a room from which the child in care is prevented from leaving by any means.
I feel like Brad's bringing up a good point. I think because we have found loopholes to sometimes be a problem, right? That it is better to be proactive and get ahead of something that we may otherwise find ourselves having to deal with, 3, 4, 5 years from now. if we're thinking about it as a possibility now, it'd be better to get ahead of it, in my opinion.
We can't do any changes. We have to go back to the beginning.
Okay, so Brenna, we need to not use the chat function. You have to say it out loud. So Brenna.
Oh, that was me. I'm sorry. That was Brad. I'm sorry. I was just grabbing some language.
Oh, sorry. Yeah, Brad. So Brad, you have to say it out loud, so otherwise it's not part of the record, and the public can't hear what you're
Okay, so this is Brad. So I took restraint and voluntary seclusion as defined by. It was just tinkering with some language.
Gotcha. Okay, so I totally get what you're saying. So we need to backtrack here. So first off, you guys already had voted for and this rule to be, was the proposed rule. We went through the public comment period, so today you need to vote on it becoming permanent, then it goes into effect, moving on. If you want to include a definition of what restraints are, you either have to move this forward today and then open rules again and talk about restraints, create a definition, or choose to not move forward with this right now, which means there's nothing in rule at all, and we start over with the rule writing process and do a number 3 and a definition of restraints. So that's kind of, we can't just all of a sudden add in a definition of restraints because it didn't go out for public comment. You didn't have to propose it before. And so, totally willing to do that, you just have to kind of pick how you want to go.
This is Sam. I feel like we need to agree to it and get it out because not having anything is terrifying to me. And then maybe we can talk about, do we feel like we need to reopen and have a more in-depth conversation around what that looks like?
That's totally fine. Yeah.
This is Brenna. I agree. I think we should adopt the rule, and we've got something in there, and we can kind of see how it goes, if there's a need to tinker further.
This McMahon, I agree.
Because we can always work on all of your rules at all the time. I mean, you know, you just have to follow through the certain process. So I think what we could do, why don't we wait until we get down to item number 9, and then, because I do believe there might be some information in item number 7 that pertains to this conversation. So we'll bring it back up again on item number 9 about moving forward with opening rules or not. So if somebody could make a motion to approve the amended rule, because we amended it by changing 4 to regarding, we can get this thing moving forward.
This is Brenna. I make a motion to approve the amended rule.
This is Brenna. I second.
Okay, a motion has been made and seconded to approve the rules with the amendment of regarding the word regarding. I'll call roll. Megan?
Yes.
Brenna?
Approved. Yes.
Corey? Corey, are you still on there?
Hi there. Sorry. I don't know what happened to my audio a moment ago. Yes, I.
All right, perfect. Thank you. Samantha?
Yes.
Brad?
Yes.
Marie?
Yes.
And Jennifer?
Yes.
Perfect. Okay, so let's go into legislation. So in here, Paul should be on the phone. So you have in here 3 bills and the letter from Paul. So he submitted that. So hopefully you guys have had a chance to read that. And I'm not going to take his thunder. So we're going to let Paul, because I put him on the agenda so he can talk. Let's get, so hopefully you've all read it. His letter's in here. The bills are in there. But Bob, you want to make sure that Paul can hear us and that we can all hear him.
Paul, are you there?
I hear you.
Okay.
Paul in here.
All right, stand by. You're pretty light here. Turn the volume up. All right. Can everybody hear Paul? Paul, say something, please.
Hi, this is Paul. Can you hear me?
Yes, we can hear you.
I'm seeing heads and thumbs. We're good to go.
Good. Okay, so my name is Paul Terdal, and I'm a resident of Northwest Portland. I'm a father of a couple of children receiving ABA services, so I'm a consumer. So I won't read the entire letter that I submitted since it's in the record. I'll just give you some basics and then happy to discuss any questions. So basically, I requested Senate Bills 358 and 355, and 355 was going to extend the insurance mandate from the 2013 Senate Bill 365 by 8 years to 2030, and nothing else. And then 358 was intended to address lots of sort of little quirks and omissions in the regulation of ABA providers. The examples would be licensed behavior analysts aren't on the list of mandatory reporters of child abuse, some glitches and really typos in the licensing statute for your board. Both were heard very favorably in Senate Healthcare. Since 358 included everything that was in 355, I advised the chair that we should just move 358 and let 355 go. We did make a couple of amendments in Senate Health, specifically I had originally put in a proposal that would have changed the title of interventionist from registered to licensed, that although that was simply a change in nomenclature, that generated a lot of confusion in lots of different directions. Some people were worried that changing the title would mean there would be much more onerous and laborious and bureaucratic paperwork requirements for their approval. Others imagined that it would give interventionists the ability to practice freely on, without any supervision. Neither of those were true, but the confusion was there, and so we just took it out because it frankly wasn't really needed for the purpose, which was making it easier to get Medicaid reimbursement. So the bill passed essentially unanimously in Senate Health. The one opposition was Senator Hurd, who has been voting against every bill this session of the protests against COVID restrictions. Nothing to do with the bill. Unfortunately, the bill went to Ways and Means for a quirk. The Oregon Health Authority submitted their fiscal impact assessment to LFO, and this agency basically said there was no fiscal impact to health licensing. For PAB and OEB, which is the public insurance plans for employees and educators, they ticked the box in the form to say no fiscal impact. But as a courtesy, they provided an estimate of how much money they were spending each biennium on ABAs for public employees, which is about $2 million a biennium, give or take. Unfortunately, LFO ignored the little tick off on the box where they said that this wasn't going to have a fiscal impact. Said, aha, you're spending money on this, so that's a fiscal thing, and gosh, maybe this is a way of saving money by cutting out ABA services for public employees. And so that got sent to the Ways and Means Committee and Settled Policy Committee. And, I included some internal emails within the health authority on that. Basically, they were trying to figure out how to explain to LFO there was no fiscal impact since they didn't really have the ability to stop paying for ABA, even if this didn't pass. That never got anywhere. What should have happened in an ordinary session is the bill should have been referred to the Human Services Subcommittee sometime around late April or early May. They should have held a hearing that would have allowed people to sort of raise any questions, resolve the fiscal issues, and then I would have expected it to move forward possibly with an additional minor amendment. Because of the way the legislative session was run this time, the subcommittees and Ways and Means basically just didn't do anything. They did not hear any bills, so far as I can tell. They had no hearings. Bills were not even referred to them until decisions had already been made to approve them, and they basically just convened rubber stamp work sessions without any public testimony, even written testimony. I had been told by Ways and Means staff, hey, you're in the queue, don't know anything going on, but yep, you're there, and just be patient and wait. The bills, basically, it looks like, yes, I'll cut to the chase, sorry. Yes?
We can't hear Paul.
You can't hear me? Can you hear me now?
I can hear you, Paul, but...
I can't hear you either.
Uh-oh. I don't know.
Is there anything I need to do on my end?
No, you're coming through to us loud and clear. They're just not hearing it. No, I'm
I
talking.
can see that you're talking, but I can't hear you.
I'm talking to Paul. They can't hear me, Paul.
Okay.
Hang on.
Everything working on that end, Heather? All right.
All of a sudden their microphone must have gone out because I can see Bob talking, but can't hear anything.
Okay. I'm gonna reboot. Send Sylvie an email, tell her I'm gonna restart my computer.
Okay, I'll hang on.
Yes,
Thanks,
please
Paul.
hang
Sorry.
on, Paul. We're trying to work on a technical issue on our side. You're fine.
Okay, thanks.
Okay.
Trampus, you're not on mute.
Okay, I'm back. Can you hear me?
Yes, we can hear you.
Okay, sorry about that, Paul. Please continue.
Okay. Great, thank you. So can everybody hear me now?
Yes, Paul, we can hear you.
Very good. Okay, thank you. So I'm not quite sure where the audio cut off. I was just reviewing the legislative process. So I mentioned we got through Senate Healthcare with a couple of consensus amendments, Ways and Means, basically because of a misunderstanding between the Oregon Health Authority and Legislative Fiscal Office. So Health Authority said there was no fiscal impact, but provided courtesy information on the amount of money they were spending on ABA services for PEB and OEB. LFO regarded PEB and OEB statement that there was no fiscal impact and flagged that as an opportunity to save money from the budget by cutting out ABA services. PEB and OEB tried to resolve that with LFO. I have no record for how that went other than to note that the fiscal impact wasn't changed. Basically, what I was starting to get into is there appear to have been some communications off the record behind the scenes between some other associations and the Ways and Means chair, specifically Senator Steiner Hayward, expressing some concerns about the bill, but also concerns just generally about ABA and scope of practice conflicts. COPAC submitted one letter, which did get into the record, expressing some concerns. I reached out to them immediately. They never responded. I did discuss their concerns with Chair Patterson and Senate Health, and we agreed that most of their concerns were already resolved by the initial amendment to remove the license nomenclature change for interventionists. That the rest of their concerns really were without merit, and so she wanted to move the bill without any further amendments to it. The American Speech Hearing Association, ASHA, sent a letter to the Ways and Means chairs, again, off the record, so it's nowhere in the legislative record, expressing some concerns. They also complained about the title change, although that had already been removed at that point. And they expressed some concerns about the boundaries and the scope of practice between SLPs and behavior analysts. Their concerns really had nothing to do about anything that was in the bill one way or the other. But nonetheless, it appears to have triggered concern by Senator Steiner-Hayward that there was an issue with the bill, and I think for that reason she just decided to kill it altogether and not do anything with it. It wasn't until we realized the bill wasn't moving that quite a large number of people contacted the legislature to ask for it to be moved, that they got it off and got it scheduled. It was originally scheduled for entire passage in the Capital Construction Subcommittee. So they originally scheduled the whole Senate Bill 358 to move. At the last minute, Senator Steiner-Hayward and President Courtney objected and said they would not allow the bill to go forward unless it was gutted. And on that basis, Representative Rayfield did the only thing he could to save the bill, and that is he basically struck everything out except for the insurance provision extension, basically turning it back into Senate Bill 355. And the net effect was that the provisions about reporting child abuse were killed. Provisions about reporting criminal convictions and unprofessional conduct were killed. The prohibition on gay conversion therapy was killed. The fixes that we put into the bill regarding your authority, for instance, over people who are falsely claimed to be unlicensed, those got killed. And the only thing we have left is the extension of the insurance provisions from, to extend it. When I called Senator Steiner-Hayward to discuss her concerns, what she told me is she didn't really remember who was raising the concerns or what they were, but that she just wanted the insurance provisions only to go forward. At that point, that was the end of the session. Everybody was scrambling to hit the exits, and there was simply no time to have any credible discussion or try and fix things. And so that's where it went. I'm trying to get a bill refiled for the February 2022 session that basically addresses these consumer protection issues and gets them plugged. There was one provision in the bill about allowing youth age 14 and up to access ABA parental consent. That appears to be where the confusion lay because of just the wording of the existing statute. I had questions. For instance, somebody asked, gosh, would this allow a licensed behavior analyst to prescribe medication to teenagers? And the answer is, of course not, because that's not your scope of practice. But because of the way it was worded, people who were not attorneys and not policy experts didn't understand what legislative counsel had written and were asking questions like that, and that basically sank it. So I think I would simply take that provision out for a bill for February and go with the things that are basic, like report child abuse, please, and stuff like that, and hope that gets through. The other, I guess, thing would raise for all of you, one is there is clearly some tension between the SLPs and BCBAs and probably also occupational therapists and some other professions around what exactly is the scope of practice for ABA. You do clearly overlap between SLPs and occupational therapists. There are things that you can do and that they can also do. But there are also things that licensed behavior analysts are not licensed to do. An example that the Speech Language Hearing Association raised with me was licensed behavior analysts helping autistic children with articulation disorders. And they were raising concerns that might be outside of scope of practice. I would suggest that is the kind of thing that really can be resolved through discussion and maybe like regulatory action or some kind of notification to say, hey, everybody, remember, you're licensed to do ABA, and ABA means this. You're not licensed to do stuff that isn't ABA. I think that might resolve the tension without getting the legislature involved. So I would encourage some discussion there. And then I think the other thing is, I know you're not allowed to endorse legislation without the governor's consent, but I would encourage in some way this board to reach out to the governor and say, there are real issues here. Literally, dog catchers in the state are legally obligated to report child abuse. Okay? Licensed behavioral analysts are not in the scope of that statute. That just is nuts. And there's no reason the legislature can't fix that. And so I would encourage the board to reach out to the governor and basically ask the governor for support to address these issues. So any questions that I can help with?
Thank you so much, Paul. Does anybody have any questions for Paul? It doesn't look like it, Paul. Thank you.
Okay, thanks. I will drop then.
All right, thanks, Paul.
Okay, bye.
Bye. Okay, is there anybody else on the phone on item number 6, which is public interested parties? So I didn't know if anybody else had logged in.
Hi, this is Paul.
Terdal?
Left.
Okay. Anybody left on the phone that would like to make comment to the board? Not hearing anything.
All right, well, we will skip number 6 then and move on to number 7. Megan, do you have your script for executive session?
Yes. Can you hear me okay?
Yes.
Yes.
Great. The Behavior Analysis Regulatory Board will now meet in executive session pursuant to ORS 192.660(2)F and ORS 676.595 for the purpose of considering information exempt from public disclosure at 10:03 a.m. on July 16, 2021. Representatives of news media shall be allowed to attend the executive session by conference call and provided further call-in instructions shortly. The public phone line will be muted for the duration of the executive session. Are there any representatives of the news media on the public phone line?
No.
Recognizing that there is no media in attendance, the public phone line will be muted.
I just want to jump in. This is Michelle Shervon in a local BCBA, and just wanted to make sure you knew that I was on the line and make sure that this is still open to the public.
We're going into executive session, Michelle. You're welcome to wait. And
Bob, will you find out if does Michelle want to make a comment?
Michelle, did you want to make a comment to the board?
No, I have no comment to make. Just wanted to make sure before I stayed on the line if there was anything that I wasn't, that I should sign off for. So just wanted to make sure you knew that I was on the phone call.
So we're going into executive session, and then we're going to have items for board action and then other board business. The items for board action will publicly state if there's any action from the executive session that's going to take place. So there's not a lot, so.
Sounds good. I'll stay on the line and wait for you guys to return then. That will be perfect. Thank you.
Okay. Did you send April Fleming an email? She did. Okay.
I did, yes.
All right, we're going to put you on mute.
Fantastic. Thank you.
All right, we're muted.
We will return to, sorry.
No, go ahead, Megan, go.
We will return to open session before taking any final action or making any final decisions. We are now in executive session. No final decisions were made and no votes were taken in executive session. The public phone line has been unmuted and the representatives of the media may once again report all board discussions and actions.
No one on the phone.
Oh, did that person hang up?
Correct.
Okay. All right, well, we'll give it a couple of minutes here for Samantha to come back on.
Do we have that person's contact information where we could let them know we're back in open session?
We've done it. Oh, the public member on the phone? No. Oh, did she email you? I think it was Freeman or something like that. Good catch, Heather.
Smith is calling in.
Samantha, can you hear me?
I'm back. I made it.
Right.
All right, perfect. All right, so we are on the agenda on item number, did April email that public number?
Yep.
So we're on the agenda on item number 8, which is a vote on cases. We don't have any cases for you to vote on today, so we'll move on to item number 9, which is other board business. So earlier today, we talked regarding, in the report section under policy, regarding the rule relating to restraints and how you guys had mentioned that we might want to define what a restraint is or is not. And so, and then also with the legislation, that those bills that passed, we could use some of that, but let's have a little discussion about what you guys want to do moving forward with rules regarding restraints. Anybody have any suggestions?
This is Brad. I do think involuntary seclusion is worth considering as an additional piece of language. And just to restate my previous comment, I mean, you know my position. I probably shouldn't restate it, but I do think it'd be helpful to either point to an existing definition or add a definition of restraint and involuntary seclusion if we decide that it's a good idea to include that in the rule. That's pretty much my input.
Okay, so I get that. So the only time that we use the word restraint is in the practice standards. So I'm wondering if, so it doesn't need to go like in a definition as in like the first, like we defined what board means, what declarant means, direct supervision, all that stuff. So I'm wondering if it might be a good idea, because it also is keeping in mind the comment that came from Arava regarding the rule, because they made a comment about maybe having a rules advisory committee. So potentially what we could do is open up Division 60, which is Standards of Practice and Professional Methods and Procedures. And in that, we can then do maybe a little bit more defining of what a restraint is and how it should or shouldn't be used, when and in whom it should, so we can get in there very clear. So it's like abundantly clear to everybody what the standards should be regarding restraints. What do you guys feel about that?
This is Megan. Could you clarify a little bit more about
like I hear like doing the definitions in where it is, and then you also talked about the rule advisory committee, so I was just curious, both of those kind of things, just clarify a little bit more.
Oh, absolutely. So you have a couple different choices. So for one, you can just say, here's what a restraint is and is not. And you can just put that in the regular definition. But if you were to do a rules advisory committee and open up all Division 60, which is the standards of practice, then that committee could then, what they would do then is come up with a recommendation to you guys, and then you guys go from there. But what they could do, potentially, is come up with a whole bunch of standards of practice relating to restraints, as in defining what a restraint is, and that, if you put all this detail in there about restraints and who can use it and when and all that kind of stuff, it would take that broadness away, and so it'd be very specific. So regardless of what setting you're in, you would have to, all licensees would have to abide by those standards of practice. So it kind of takes that away from it being a policy within say a company, for instance. If they had a policy on restraints, their policy could not be any looser than what our rules say. They could be stricter than what our rules say. Does that kind of make sense?
Yes, thank you.
Megan, what do you think of that?
I think I'm currently undecided. I feel like there is benefits to having a rules advisory committee and having that much specificity put in there, but I don't know all the implications of what that would mean on a practice level throughout all settings.
Well, I guess I have a question for the rest of the board, which is the reason I was proposing that was that I was trying to think about this from the perspective of the investigators at the Oregon Health Authority, and when there is a issue around restraint or involuntary seclusion, and they're trying to, I don't know, I guess adjudicate isn't the right word, but trying to discern, like, it just seems like not having that defined creates a space for there to be disagreement between the licensing authority and the licensee regarding what is and is not. They could say, well, all I did was, I was just helping him perform the skill, and so it just seems like that was the reason why. But if nobody else thinks maybe the rule is just fine as it is, and it doesn't need that additional definition. I was just thinking about it from the perspective of when there is an issue, how do you discern what is and is not a restraint? Because that's why it's defined in legislation. So anyway, but if nobody else thinks it's needed or that's going to be an issue, then I'm not stuck on it or anything. I'm just putting it out there.
I think I think there's some precedent there for this. However, in making a definition for what restraint is, that it's not uncommon that there are specific definitions for things, procedural rules.
I mean, this is Sam. Behavior analysts really like operational definitions. I feel like my only hesitation is that we'll get real intense with it. It's going to take us forever. But I think we need to define restraint and seclusion because there is a lot of wiggle room just in the words itself. So yeah.
Well, there's the Senate bill language. It says, so Senate Bill 710 says, restraint means the physical restriction of a child in care's actions or movements by holding the child in care or using pressure or other means. And then there's a definition for involuntary seclusion. It's only one sentence, so it's not, you know, the language isn't extensive.
Yeah, the downfall of that statute, though, is doesn't it pertain to schools? It talks about specific setting, it's not our setting.
This is the one that relates to children. This is the one that Senator Gelser pursued in the 2021 session. And let me see. I'm trying to.
Yeah, so it talks about, this is the one that talks about, it's pertaining to a certain type of environment. So this is under DHS and schools.
It's broader than schools. Child care agencies, proctor foster homes, developmental disabilities, residential facilities. I think this is the one that maybe had some language in it that O'Raba was concerned about, and that was then Senator Gelser then adjusted it, if I recall correctly. But anyway.
Yeah, because all of these changes, I'm looking at the bill right now, all of the changes relate to statutes 418, and you guys are not 418.
Let's do it, Joyce.
Yeah, I think this is Brenna, I think what Brad is probably saying is that that's, you know, if we wanted to define it in the rule, that's one source of the definition. As I recall, the sort of issue is with that language is that it isn't, you know, what's the difference between blocking and restraint, right? I mean, if the kid is fixated on something that you don't want them interacting with for whatever reason, standing passively between that thing and the kid is a, you know, pretty constructive thing to do, right? But then there's a slope between, you know, standing between a kid and an item you don't want them accessing, and standing, you know, putting them in the corner and then sort of standing in front of them, right? And in one instance, you're preventing the kid from accessing a thing. In the other instance, you're controlling that kid's movement, even somewhat passively, right? And so,
yeah.
I mean, I did, like, you recall when we first went down this path, right? Like, we gathered, you know, policies from various centers, and, you know, they weren't, as I recall, they weren't that different, you know. I mean, they were clear, and they were detailed, and, you know, they were pretty standard of practice. And so that's why we ended up where we ended up, which is to say, okay, centers or okay, practitioners, you have to have a policy. What you have in that policy is up to you. Because we really didn't think that anyone was going to come up with a policy that just says, you know, restrain away, have at it, or, you know, and that way, you know, centers would be free to, or providers would be free to tailor their strategies to communicate best with the parents and other, you know, people that they need to communicate with. And I'm still okay with that. I don't really know that we've discovered that there's a problem with that. And especially if it's the center's own policy, we can't, like, they can't very well argue that it's like somehow our fault or the kid's fault that they didn't understand it, right? It kind of puts it on them.
Yeah, I'm in agreement, and maybe we just leave it alone, and if we see that there's an issue down the road, then we revisit.
I would agree with that. This is Jennifer.
And again, like, some of the things that I think in specific we're concerned about, you know, like, we haven't, like, they gotta be in violation of the practitioner's policies, right? It's difficult to imagine a policy that would sanction those activities and would still comport with professional standards. It's, you know, maybe see kind of a disconnect between, you know, what the policy is and the fact that, like, you know, due to a lot of concerning reasons, clinical direction is just kind of in opposition of that policy, and nobody's gone, oh, wait a minute. So maybe what we really need to do as a first step, right, is to leave the rule as it is, and then just kind of see what we can do to bring about an, oh, wait a minute moment for the profession, for the people that we're regulating.
I'm totally fine with that. Yeah, because we could send out because Ann's gonna already automatically send out, which she does, this is just part of our process. She'll send out to all licensees the rule change, because, you know, that's how we do it. So they'll get an email that says, hey, this new rule is in effect, you know, and so obviously, and then she also sends it to all interested parties. And so it'll go out to all those lists about the new rule change. And then once that rule is in place, then we can kind of monitor to see if we're still getting complaints on issues that rule we were hoping was fixing. Then we can open rules. We don't have to do anything right now.
And I wonder also, if we can, pair that communication with something that says, so licensees, if your policy says that you're not going to use restraint or seclusion to obtain compliance, then that means you don't use restraint or seclusion to obtain compliance, and we'll consider that a violation of the rule. And if you use restraint or seclusion when something else would suffice, that also is something in violation of your policy. That is also something that will be in violation of this rule.
I hear you.
And if I were a RADA member, I would wonder if now isn't the time for some a little training.
Right? Yep.
Because apparently there's an issue.
Yeah, because even the new rule that we just approved says that the policy will be one piece of information considered by the board or the office in determining whether a restraint used on a client constitutes unprofessional conduct, negligence, incompetence, or failure to conform to standards of practice. So we wrote that pretty good. So if they don't abide by their own policy, we'll have some pretty good teeth to be able to cite that rule and say, here's what you violated.
Yeah, so if we can do a communication that, connects those dots, like that, that may be something we can do in the immediate without further regulatory activity that, could help.
Yeah. I hear you. Anybody else have any other comments on so I'm under the assumption we're going to go with this rule for a bit and not open up rules back up and have a rules advisory committee at this time. We'll talk about it maybe in January.
Sounds good.
Okay. Another thing that I wrote down is somebody had made a comment about whether or not facilities have to be licensed. And it's my understanding that some of these facilities where kids are brought in, they are not licensed, but that does not mean, I know we do not license them, and I'm not sure that anybody specifically does. And if that is something that so us as a board can't do it, and us as an office can't do it because we can't introduce that kind of legislation. But I would be willing to work with anybody who would want to do that. But in order to require a facility to have a facility license, that would be a statutory thing. So that would be where somebody would introduce a bill to the legislators. And it's happened in the past. So there are several, especially for us too. So we license and regulate individuals. We do not, we have a couple boards where cosmetology is different, because for cosmetology we license and regulate the facility and have their standards of practice and stuff, but that's because cosmetology has been around for a very long time. But some of our professions where we license the individuals so for instance, like nursing home administrators or residential care administrators, their homes themselves, the home, depending on how many beds they have a different type of license. But those licenses for the facilities are done through Department of Human Services, and they have their own set of rules and statutes that regulate the facility, and then we license and regulate the individual running the facility. So it's not uncommon for that to happen, but as of right now, the facilities, as far as I know, for ABA are not licensed.
Do any of the BCBAs in the group know if there's precedence for this in other states where states license ABA clinics?
This is Sam. I know that there are people working on it. I want to say last I heard there was one state that was passing some type of regulation on ABA clinics, but not that there's no successfulness yet that I know of.
Well, when I think about like analogous, school clinical psychologists, private SLPs, I'm not aware of those clinics and private practices having it's like, I think it's a great idea because of, or it's a potential remedy for some of the issues that can come up, but I just wonder how far outside, if there's precedence for it, or if it's kind of like a good idea, but it's maybe not, or it's not quite the right way.
It's a common conversation because what happens is if a BCBA doesn't own a company, then that company, like we're seeing with CARD, has literally no regulation over it, right? So like I own a clinic. So if someone wants to, if we do something terribly wrong, they can file a complaint against me, my BCBAs, and essentially shut down the whole place. With CARD, to be honest, they could blow things up and we could do absolutely nothing about it. And because the profit margins on EBA are very, very high, there tends to be a lot of private equity firms, which is why I think it's becoming more of a conversation. So they're similar to psychology services with the exception of the fact these are now multi-million-dollar companies. And these kids are in 30, 40 hours a week. I was just trying to pull up.
I'm so sorry for interrupting you. The other to me main distinction is, the service model is quite different in the ABA world, right? Where you've got these really skilled, highly trained behavior analysts, and then they're supervising this much wider group of professionals that have a much lower level of training. No disrespect, yeah. But so if you have a clinical site, that clinical site is delivering 100% of their services most of the time. SLP might have, no, for the most part, that's true of SLPs too. So there's a different dynamic with BCBAs, relative to the work of the behavior technicians that I think warrant some special consideration. But
yeah, I'm on APBA just to see if there's if I can find anything about who is regulating it. Okay.
And the other point you make, Samantha, is I'm just pontificating here, but if there was a move to do this, it would catch a lot of attention from, it would be I predict a animated dialogue in the state, and it would be in there, there'd be some real intense.
I think I'm fully in favor of it because places exist. What we saw today on the video, that's light. The things that have come through our doors that we hear from clinics that are not great is horrendous. But yeah, it would be a hot topic. It's a huge thing to take on. It's also very, very necessary because, like you said, if the RBTs aren't trained properly and they're there by themselves and all kinds of things happen.
I can see how they're scrutinizing the conversation we're being careful not to talk about anything from executive session, but back up there, rather.
So yeah, I can't find anything on APBA yet. It looks like Indiana was trying for a clinic licensure. I'm going to reach out to Tyra and find out if she knows anything.
Yeah, definitely. This is Sylvie again. Definitely reach out, see if you can find any information. We can talk about it again at your next board meeting, especially if you get any information. And then if you find any information that you want to share with the group, please do not email each other. Email Ann or me or Bob, and then we can then get it out to the board members. We just want to make sure that we don't accidentally, have you guys all communicating together. But then we can also put it as the materials and talk about it at the next meeting too.
So can I ask
Yeah, I'll just take it.
Like Corey and I are on the Autism Commission together. Am I hearing that we don't really, as board members, we don't want to be having these kind of one-on-one conversations with each other around board-related business? Is that what I'm hearing you say?
Two people, one-on-one, you two, no, that's not what I'm saying. What I'm saying is when you all, so for instance, if Samantha got some information and sent an email to you all, that's a board meeting, you all are talking. So as soon as you get to quorum, which you're a board member of 9, so as soon as 5 of you get together and talk about something, that's a quorum, that's a board meeting. So that's what we want to prevent. But
Okay.
2 of you talking about something,
All right.
And then the other thing too is, and the best thing to do is just to say, to not talk about board business, because then you just kind of stay away from the whole issue to begin with. But for those of you who are in the profession, it's hard because it's your profession. So you can, when you're talking about restraints, the board's talking about restraints, but also restraints are a hot topic right now. But it doesn't mean it's board business. So you just kind of keep away from saying, at the board meeting the other day, we said blah, blah, blah. But if you're talking about restraints, you just talk about restraints.
Well, if there's this legislative concept around licensure of clinics, that's one that really should, be that people should talk about and dialogue. But I hear the distinction that you're making.
Yeah.
So Brad, it's a public record, it's an open record thing, right? Like we're supposed to be regulating in a publicly accessible way.
Right.
So that means we shouldn't be regulating when we're not publicly accessible. That's the thing, right? Like if we share communications that don't end up being captured as public records, then we're subverting the public's ability to supervise what we do as a board.
Perfect. Thank you. It's helpful.
All right. Any other discussions that anybody wants to have?
So we're just going to gather information and then revisit in January.
Correct.
Okay.
Correct. So basically you have homework. So if anybody can find anything, and I can also talk about how legislation works. Most of us all know who Paul is. And so, I don't know if that's something that he is interested in or not. Somebody could talk to him about that. I can talk about the process. If we do finally get to the point where somebody wants to move forward, like I said, I'm more than willing to work with anybody. We just cannot bring a legislative concept forward. So their homework is to find any state that has done anything, maybe a little bit of research on anything that pertains to why it might be a good idea. But again, if there's anything that you think is relevant, send it to us. We'll make sure to include it.
Well, and can I just add that, the conversation, the rationale for the conversation, I think, if I'm framing it accurately, is the board has an interest in ensuring or promoting that, behavior analytic principles are appropriately applied, in an ethical way, and that so that children aren't harmed or that situations aren't mishandled. So we've talked about one possible way to address that, but there may be other avenues to influence that issues, and so maybe that's another thing that's worth thinking about.
Right. And it kind of goes along with what I think Paul had said at one of the meetings not too long ago about and maybe Brennan, you might be able to add to this, but it's kind of that same kind of distinction that he brought out with the school districts. So they have their own statutes and their own way that they deal with the school districts and children who come in or in the school versus how ABA is done in the home and bringing your personal ABA into the school system with the child. And so, Brenda, I don't know if you can add to it, but that's kind of like the schools are regulated and it's different than like the interventionist or it could be an interventionist that goes with the child, and what the interventionist can and cannot do when it's in that school environment versus when they're in the home environment kind of thing. Brenda, do you want to add to that?
Yeah, I don't know if we have any clarity around any of that, right? I mean, there's, schools have policies and laws about restraint. I don't think, I don't know, I would be stunned if there were a private practitioner that was restraining a kid in the school without the school's involvement. Generally, I don't think there's a lot of clarity around that, but I also don't know that that's anything that we're going to make any progress on.
No, Brenda, what I was mentioning or trying to mention, I certainly didn't obviously did it good enough, about who gets to tell whom what to do. So when you have a for-profit company that says you will do A, B, and C, and then the interventionist or the analyst is like, no, that goes against my standard. And it's like, well, we're the company, and if you don't want to work here, you know, that kind of thing. And which kind of similar.
I see.
Yeah.
I see what you mean. Yeah, I mean, we did have this conversation a few legislative sessions ago, right? That if you've got, a company that makes a decision that directs a BCBA to violate a standard of practice or a patient right, then, who's held accountable and where we're at, right? Is that, our choice is to is to take disciplinary action against the individual that we're regulating, right? And it's the same thing as a law, right? I mean, if my law firm says we'll fire you unless you do this unethical thing, I just have a hard choice to make. The bar doesn't have jurisdiction over my law firm, just my license. And so, it feels pretty aggressive and, unfair in some cases to hold people responsible and, when their patients and their own economic interests are placed in conflict. But, if that's where we're at, I think that's where we're at, right? I mean, at some point, kids are being harmed. And I think it's going to be really difficult to get to a place where we can do something that's really going to get the attention of a private equity firm to change a policy, in a business, right? I mean, but communicating to the provider community that, there are certain employers that they don't want to find themselves working for, that's...
Ronna, you'd be surprised. I just got off the phone with a private equity fund that's worth $8 billion and convinced them to do lots of things that are in the right direction. So we can get closer. It just takes a lot of finesse work.
Yeah, it may be, right? But it may also be, we can't find BCDs who work for us because we don't provide conditions in which they can do the things they joined this profession to do. Right. I just don't know.
Remote BCBA.
Yeah, I mean, that may be it. I mean, I don't know, right? I mean, I've been warning parents away from, I spend a lot of time talking to, the parents who are anti-HIV about, how to make sure that ABA for their kids is constructive and, non-harmful. And, a lot of it is working towards goals and behaviors that are, meaningful for the family and the kid instead of easy to measure and, implementable by somebody who doesn't really know what they're doing. There's probably a lot of input.
Yeah, and I think, this is Sylvia again, I think, for one, you guys are, and it's a big realm of things. This is still a new license. And so we're still learning as we're going, and I think that there's always opportunity to add rules. We obviously don't want them to be so restrictive that they start, having a negative impact. But just because the rules are written the way they are now does not mean they can't change. So down the road, if we need to, we can start tightening up the rules to address issues that are not being done by some of the, if some companies are not doing something, we'll make sure that the rules are very clear so that the analysts know what they should or shouldn't be doing, regardless of what the quote policy is from some company. So, future thought. We don't have to make any decisions today. It's just great little talking about it. So, we can talk about it more when you guys meet in January. Anything anybody else wants to bring up? Alrighty, well, if not, Megan, you should have a script for adjournment.
The Behavior Analysis Regulatory Board meeting is adjourned at 12:55 p.m.